noted by this court. The matter also warrants a reference to State versus Traynor, 2003, 1 SACR 35 SCA decision, paragraph 9. A conspectus of all the evidence is required. Evidence that is reliable should be weighed alongside such evidence as may be found to be false. Independently verifiable evidence, if any, should be weighed to see if it supports any of the evidence tendered. In considering whether evidence is reliable, the quality of that evidence must of necessity be evaluated, as must be corroborative. It must be therefore corroborative evidence, if any. Evidence, of course, must be evaluated against the onus on any particular issue or in respect of the case in its entirety. It should also be noted that the high standard of proof universally required in civilized systems of criminal justice is a core component of the fundamental right that every person enjoys under the Constitution to a fair trial. It is an inevitable consequence of living in a society in which the freedom and the dignity of the individuals are properly protected and also respected. Therefore, convictions based on suspicion or speculation is not permitted. The court also needs to mention the chain of custody, being the document of activities, or explained as being the document of activities performed on digital evidence by recording its control, transfer, analysis, and disposition during criminal cases. It is crucial to maintain a complete chain of custody report to ensure that evidence is not compromised at any point from the time of collection to its court presentation. It shows who has collected and accessed digital evidence when the evidence was transferred. Typically, a chain of custody report must include the following information to maintain a detailed log of activities performed on digital evidence: the name of the investigator or police officer who collected the evidence, the time and date when the changes have been done in the evidence, uploaded and viewed. There is no need to say that digital evidence is a key element in solving criminal matters. In order to prove the guilt of an individual or not, prosecutors must therefore justify that the evidence presented in the court is as original as collected at the crime scene. Therefore, the chain of custody is more important than digital evidence. Of evidence in court, what is required is a detailed log of aspect that the court needs to place on record pertains to the evaluation of expert witness testimony, and I emphasize the requirements. The court must be of the opinion that the person is an expert and competent to testify as an expert. The expert testimony must comply with 3 basic requirements: the basis for the expertise and the expert's qualifications, experience, and expertise, and specifically knowledge must be put before the court. The basis for the opinion and reasons for the opinion must be put before court, which was used or based on the facts in the case. Personal knowledge of the suspect. I emphasize personal knowledge of the subject being the exhibit. State versus Engelbrecht 2005 to SACR 41 in brackets WLD bracket. It cites that courts frequently turn to persons with expertise and skill for assistance. The relevant principles applicable to the admissibility of opinion evidence by experts have been set out in numerous authorities. Firstly, the matter in respect of which the witness is called to the expert should be sufficiently relevant to the matter in issue to be determined by court. Fourthly, the expertise of a witness that the court as to replace the court's own capabilities and responsibilities and the facts within the personal knowledge of the expert or on the basis of facts proven by others. The sixth of the evidence, including corroboration of the evidence. The opinion should be accurate, impartial, and objective. The court should therefore evaluate whether the witness is in fact an expert in the field and whether the expert's opinion is based on sound reasons, which is based on the facts presented. The expert's opinion is based on sound reasons, which is based on the facts presented before court, including accuracy and reliability of the opinion, objectivity and impartiality. Further, whether the court's factual findings in the case supports the expert's opinion. Again, accuracy of opinion and to the extent to which the expert's evidence is undisputed and or corroborated by factual findings, thereby the reliability of the opinion. And further, whether the opinion is objective, impartial, and safe to rely on. Just a minute. The matter before court, even if it's the media. Oh no, I was going to say the media, if it's them, they must leave now. You took responsibility, so I'll leave it at that.
I honestly don't know how this thing can go.
I wouldn't know. As stated, in the matter before court, a discussion pertaining to circumstantial evidence is required. The difference between direct and circumstantial evidence is important. Various case law states that circumstantial evidence is not necessarily weaker than direct evidence. In some instances, it may even be of more value than direct evidence. Inferences are drawn from circumstantial evidence, and in this process, certain rules of logic must be followed. It is also required that the court should always consider the cumulative effect of all the items of circumstantial evidence. It is also a well-accepted principle that the court should not consider each circumstance in isolation and then give the accused the benefit of any reasonable doubt as to the inferences to be drawn from each single circumstance. The approach can also be put differently. The state must satisfy the court not that each separate item of evidence is inconsistent with the innocence of the accused, but only that the evidence taken as a whole is beyond reasonable doubt inconsistent with such innocence. And now I know citation of the following matter always elicits questions. The well-known dictum in R versus Blom, 1939 AD 188, has been cited with approval since then in all case law pertaining to circumstantial evidence up to date and remains the principle or the basis of the evaluation of circumstantial evidence. This dictum has been cited with approval in cases, example, S versus Steinberg, 1983, 3 SA 140 Appellate Division, State versus Van As, 1991, 2 SACR, 74 Witwatersrand, and in State versus Reddy and others, in brackets 416/94, in brackets 1996, end of bracket, ZA, Supreme Court of Appeal decision, handed down 28 May 1996. The court will now deal with the evaluation of circumstantial evidence, including the cardinal rules pertaining thereto. As stated, evaluation of circumstantial evidence in State versus Reddy and others, citation on record, states clearly that in assessing circumstantial evidence, one needs to be careful not to approach such evidence upon a piecemeal basis and to subject each individual piece evidence to a consideration of whether it excludes the reasonable possibility that the explanation given by any accused is true. The evidence needs to be considered in its totality. It is only then that one can apply the often quoted dictum in R versus Blom citation on record, where reference is made to the two cardinal rules of logic, which cannot be ignored. These are, firstly, that the inferences sought to be drawn must be consistent with all the proved facts, and secondly, the proved facts should be such, I quote, that they exclude every reasonable inference from them save the one sought to be drawn. This is well worded in the remarks of an also very old case law, Davis, AJA in R versus de Villiers, 1944, AD 493 at 508. The court must not take each circumstance separately and give the accused the benefit of any reasonable doubt as to the inference to be drawn from each one so taken. It must carefully weigh the cumulative effect of all of them together and it is only after it has been done so that the accused is entitled to the benefit of any reasonable doubt which it may have as to whether the inference of guilt is the only inference which can be reasonably drawn. To put this matter in another way, the state must then, as stated, satisfy the court that each separate fact is as stated, the state must satisfy the court not that each separate fact is inconsistent with the innocence of the accused, but the evidence as a whole is beyond reasonable doubt inconsistent with such evidence. A number of circumstances, each individually very slight, may so tally with and confirm each other as to leave no room for doubt of the fact which they tend to establish, though each taken by itself weigh but as light as a feather. However, join them together, you will find them pressing on an individual with the weight of a millstone. It is further described that in cases surrounding circumstantial evidence and circumstantial evidence alone, evidence varies infinitely in its strength to the variety, the independence one of another, and one might describe it as a network of facts cast around an accused person. That network may be that strong as it is in part and it may also leave gaps and may then allow the accused person safe passage. It may be so close, so stringent, so coherent in its texture that no efforts on the part of the accused can break through, and it may come and it may also come to nothing, and or on the other hand, it may be absolutely convincing. The law does not demand that you should act upon certainties alone. We often ought to act upon just and reasonable convictions founded upon just and reasonable grounds. The law asks for no more and the law demands no less. I further State versus Kwanda, 2013, 1 SACR 137, Supreme Court of Appeal, where Mareje stated that such an inference is only justified where the state has established facts from it can properly be inferred by a court. Now, in the instance, and as I've stated, in an attempt to summarize the facts in dispute, it basically comes down to whether accused one fired a real firearm on the day in question and whether such firearm was provided to him by accused two. To an certain extent, also whether Colonel Mngwadleka correctly linked the cartridge found to the firearm CN SPA 24914, the chain evidence regarding the gearhouse footage since the laptop used on the said evening had been stolen, and whether the state proved the authenticity of the now known called viral footage, and whether the CN SPA 24914 was in East London on the said date, and firearm in effect was fired on the night in question was a real gun or a toy gun. That in essence is the pertinent question that this court needs to answer to today. The common cause facts in a summary form is that it is common cause that the EFF hosted an event being their 5th birthday celebrations at Sisa Dukashe Stadium, Mdantsane, East London on 28 July 2018. Mr. Malema and Mr. Snyman were both present during the event. The event was recorded by Gearhouse Company. At some point during the celebrations, Mr. Malema fired shots in the air, be it with a real or toy gun. Therefore, the court is not saying it is a real or a toy gun, merely it's common cause or that a firearm or toy gun was fired. Shots were fired. That point, full stop. Mr. Lemma confirmed in his evidence in chief and through instructions by Advocate Holders that he fired shots, however, with a toy gun. I mention this as common cause since it is evidence of the accused one himself that he fired shots. That the shots fired by Mr. Malema with the said object emits a muzzle flash. That Larry Mavundla was present on the day in question. Further, that VIP protectors were assigned to, I quote, body watch, unquote, Mr. Malema, 2 being from the Eastern Cape and the other from Pretoria. That a cartridge case was picked up after the event, or that a cartridge case was picked up at the stadium on the Monday morning, and the event was held on the 28th of July 2018, a Saturday, and they left about 2 a.m. the following morning. The said cartridge was picked up by the cleaning staff of the stadium and grounds on the Monday, being the 30th. The tactical security company was registered and that one, Mr. Mduli, was the responsible person at the time, however, was ill and in hospital at the time of the event. All firearms were dispatched in batches by accused 2 for ballistic testing. All firearms were returned to the above-mentioned company. That an audit of the registers of tactical security was inspected, which commenced on Friday, the 3rd of August 2018, and continued on the Monday, 6th August 2018. At that stage, where SAPS was about to leave, Mr. Larry Mavundla arrived with 2 firearms, a 9mm Glock handgun, and a rifle SPA 249-14, and it is said by the defense saying that the firearms was called in to be provided to SAPS for ballistic examination. Further, all registers of the company was in order and all firearms, be it, and I say accounted for, it is indeed accounted for in the register as inspected by Colonel Jansen in the KZN office, indicating the amount of rifles being booked out and the reference made of the 2 that was returned. I hope you understand the way I am stating this. Therefore, the ones who were booked out, save for the 2 presented, I accept it was booked out per the register, but that was not returned on the same time, at the same time. Further, at the stage where SAPS was about, okay, I've stated that, sorry. As per Exhibit L, statements by Warrant Officer Small being a confirmation that Tactical Security Services was found to be compliant with all requirements in respect of all 221 firearms and ammunition. The premises was also found to be in compliance of legislation as to how and where firearms and ammunition should be kept. Accused 1 and 2 are known to one another since 2008. Mr. Malema uses the services of tactical security for his personal protection. Now the court will venture on the following. Much has been said regarding the viral clip, the viral footage being clip 3. I want to deal with the clip as follows, and that is what facts remain proved on record should the court not include the viral footage. 1. That the event stipulated on record occurred on the date, time and place mentioned on record. The footage is not needed in that regard. That Mr. Malema is on the stage and fires an object which resembles a gun or rifle in the air and it emits muzzle flash. That Mr. Snyman was present on stage. The 5 statements placed on record by the defense for accused 1. A cartridge was picked up on the grounds of the said stadium and handed to the supervisor, who in turn handed it to Captain Swart, who sealed the cartridge in an exhibit bag. All state witnesses called, being the employees of Gearhouse Company, remains facts on record, and that they recorded the event, that after checking the recording on the laptop, it was downloaded on a hard drive, and also further checking that it has indeed audio. Thereafter, the laptop is cleared for further events and the hard drive is kept intact. An inspection was done by SAPS of the premises of Tactical Security Services and all registers were corresponding. The CN SPA 24914 is the property of Tactical Security Services. The said firearm was booked out according to the registers of Tactical Security to Mr. Larry Mavundla. Mr. Mavundla was in East London and attended the event, and he was also said to be on stage. Therefore, it is also without reference to video clip 3 that he had left the firearm in Gauteng. Therefore, he was no longer in control of the firearm that was booked out to him for his use when necessary. Accused 1 departed from East London on 30 July 2018. A compliance letter in respect of tactical services as mentioned. Therefore, in essence, all of the above facts remain without needing the viral footage to support these facts. Further, all firearms checked by the ballistic unit as per batches received and returned remains unchanged, that a toy or movie gun may emit muzzle flash. DNA and fingerprints were not linked to Mr. Malema or, if tested, are to accused 2. Therefore, again, the only aspect to be determined is whether the rifle fired by Mr. Malema was a real firearm or not, and the court is of the view that the viral footage is not needed to enable the court to arrive at a finding in this regard. As a side remark, it should be noted that the very same viral video footage was used by the defense to indicate certain factors they wanted to be placed on record, and in the same breath, the court is asked to rule that the viral video footage is inadmissible based on the fact that the originator of the said footage was not traced and called as a witness. Therefore, even though the court ruled the said footage as real evidence, as it is relevant, but it should be excluded as it was not authenticated. This leaves the question as to why the defense relied on the footage during their cross-examination of the state witnesses to emphasize certain factors or facts, and it was also used by the defense during the presentation of the defense case in respect of accused 1. Further reasons that remain without reference to the viral footage is the Gearhouse Company footage was downloaded on a hard drive which was kept safely under lock and key by Mr. Singh. He was the only key holder of the said safe, and it was only unlocked when the officer from ballistic unit arrived. The procedure thereafter as to the downloading by the various individuals placed on record as per facts was confirmed in evidence that it is indeed the recording recorded by Gearhouse, and that the snippets that was viewed regarding clip 1 and 2 was indeed part of the recording that was recorded. I will admit and mention the Gearhouse footage is not as visible as the viral footage. But in this regard, therefore, the Gearhouse footage is ruled as real evidence. It is relevant, it was authenticated, and therefore it is ruled admissible. With regards to the viral footage, I've stated the facts which the court will rely on without giving any any real regard to the viral footage, and no further finding is required regarding the said footage. Now, please bear with me. As I said, I tried to summarize all in a less quantity. Okay. Therefore, the court will now reach findings regarding the credibility and probability findings by the court in respect of the state and the state case. Firstly, the state witness that testified before court are found, based on the evidence placed on record yesterday and the day before, to be credible, reliable, and truthful, and the court cannot find any bias, prejudice, or any motive in the evidence of any of the state witness to indicate otherwise. Mention needs to be made with regards to the evidence of Colonel Mgwadleka. Safe to say that he was a brilliant witness and had left no stone unturned. He had dotted every T and dotted every I. He had not made any mistake as far as the custody chain or the handling of the exhibits or the serial numbers contained. The court finds him, and all the above then, as stated, credible, reliable, and truthful. However, the evidence of Colonel Mgwadleka during his testimony was checked in the working case file, which the defense had insight of. And with reference to the evidence of Colonel Mgwadleka, the court has placed the procedure regarding the evaluation of expert witnesses on record already. He meets the criteria. In fact, he exceeds the required criteria in his thoroughness, and he can be, or he is mentioned by this court to be not only an expert witness, but a super qualified expert witness. That is the conclusion regarding Colonel Mgwadleka. I've already dealt with the gear house and the admissibility. However, I want to emphasize that the further aspect regarding the laptop that was stolen and mentioned as a reason, the stealing of the laptop is a non-event. It does not affect the chain of evidence regarding the gear house. The gear house starts where it was confirmed by the employees that the hard drive was indeed depicting the correct footage they're recording. Thereafter, they clear it for space for future events. Therefore, the theft of the laptop is neither here nor there. It's not a factor this court needs to consider. Okay. Now, in dealing with the defense case, the following is placed on record during the evaluation. The evidence of Mr. Hood is noted and greatly appreciated by this court, including his extensive knowledge with regards to the provisions of Act 60 of 2000, and it is so acknowledged by court. With regards to Mr. de Klerk, as per the cited requirements already placed on record in the evaluation of expert evidence, and specifically with regards to, I emphasize, the personal knowledge of the subject stroke exhibit, he did not examine the cartridge or the said SPA 24914. Further, he had examined all the other firearms and rifles which are not relevant to this case. Therefore, it is noted, and that is the only finding I can make on those tests conducted. However, it needs to be noted that during cross-examination, the witness was indeed a defensive witness and at stages argumentative. His evidence mostly relates as to, and then he continues stating, if I can put it more clearly, the report deals with the evidence and how it relates as to what the microscopic examination entails or should entail, and all exhibits thereafter is not relevant to the case. He states, in the matter before court, the witness testified that he used his mere eye or magnifying glass. Therefore, he also mentioned the second ballistic expert present in court. I must highlight this was a second expert was not called, so it is merely with regards to cross-examination regarding the two ballistic defense witnesses present in court is a non-event. It is disregarded as a mere statement placed during cross-examination. On evaluation of the evidence of Mr. de Klerk, the mere eye or magnifying glass can never stand or be accepted in the light of the ballistic expert witness, Colonel Mngwadleka. It falls short and can only be noted as mediocre. However, I do not imply that he is not an expert in his field, but highlight the fact that also he did not receive peer review, and at times his answers in cross-examination was extremely sarcastic, and what comes to mind was on being questioned regarding the amount of cases finalized by or examined by Colonel Mngwadleka compared to his response was, I quote from memory, good for him, consider the years of his service at SAPS, and then you compare it to my years of service at SAPS. And in event, the witness left the services of SAPS approximately 30 years ago. That is all that can be said regarding the evidence and the defense case on behalf of accused 2. No positive findings is made in respect of the Exhibit M. With regards to accused 1, on evaluation, it was evident that the only aspect to be decided on was whether he fired a real or toy gun. The said firearm, toy or real, was indeed handed to him by Mr. Mavundla, and during his evidence he testified that Mr. Mavundla should have been charged. This begs the question, charged for what? Handing you the toy firearm, or then alternatively the SPA 249-14? The answer is nonsensical as to why Larry Mavundla should have been charged. In effect, the further particulars indicate from Larry Mavundla as per A121. And just to elaborate on one aspect, sorry, I need to revert to the defense case on behalf of accused 2. Apologies, number 1. It also comes to mind that Advocate Matthews had put to the witness that being Colonel Mngwadleka, he had received instructions from the said protecting officer, being Larry Mavundla, that the breech block of CN SPA 249-14 has not been changed or altered in any manner. Now that statement remains a mere statement. The person who on whose instructions Advocate Matthews placed this statement to the witness was not called to substantiate. Therefore, it is a mere statement done in cross-examination. It also further then begs the question, if he had left the firearm in Gauteng as stated, he cannot make such a version or instruction to Advocate Matthews because in his version or their version, he had not possession of the firearm during that time. Now, to return to accused number 1, I've dealt with as to why he states Mr. Mavundla should be charged. He also relies on the video footage of clip 3. I mentioned this as a mere reason that it was part of his evidence, and he identifies Mavundla, who was not called to testify, and identifies Chauke. Now, when read the statement regarding identifying Chauke, read with Chauke's evidence or statement that he was not on the stage or present on the stage, leaves a question mark. During cross-examination, which I've already placed on record the aspects, the evaluation is as follows. Mr. Malema had evaded many questions that had warranted a reply. It became evident that the replies were entertaining, but however, the pertinent questions asked remained unanswered. He further relied on clip 3, and he had then counted 15 shots fired, and thereafter stated he cannot count, he had graduated in woodwork. Further, as to how the cartridge or the SPA 249-14 is linked to him, his reply was it must have been the Holy Spirit, and these type of answers did not do accused one any favors. In essence, when one is questioned in the witness stand and a mere question is asked from you, which elicits a response, one would expect that the question will be answered. Therefore, the court needs to deal or to establish whether the version presented by the defense is reasonably possibly true. I have already stated all the factors that remain intact, excluding the video clip 3. Just a minute. You put me under pressure with this time limit, so I just need to sort out my documents here. Alright, now the court will proceed with the findings made in this matter, and as stated, the findings are based on the rules pertaining to circumstantial evidence, keeping in mind the 2 cardinal rules already placed on record, but which the court will repeat at a later stage. Firstly, the inference, or it can be said that all the relevant persons as per the evidence of this entire case were in East London, that the firearm booked to Mr. Mavundla was according to him, not in his personal possession, but no explanation has been given as to where it was kept in Gauteng. The registers of the KZN unit indeed states it was booked out to Gauteng Larry Mavundla. But where was it kept since 28 July or since his departure in Gauteng? Mavundla, through Advocate Matthews, informed him that the breech block was not changed or altered. And now if he left the SP 249 in Gauteng and came to East London, it was not in his personal control as stated. However, the question is seen as a mere question put during cross-exam and remains just that, a statement in cross-exam. Therefore, the person who informed Advocate Matthews of this fact then should have been called, and he is in no position to give such information since it is his version of the defense that the firearm was in Gauteng. Now, as to what happened and where it was kept, no explanation was provided. It begs the question, dealing with circumstantial evidence, that what does the firearm being booked out to Mr. Mavundla in effect equates to? That specific firearm is booked out to him for whenever it is needed for him or by him, since clearly it does not mean it needs to be on his body since he left it in Gauteng. Further, on considering those aspects, why would the two firearms in question be called in and said please take this for ballistic testing? However, the others that were booked out in the register was not brought in on the day Colonel Jansen left on the 6th. Just the two in question. Further, the court is obliged to look at that the said cartridge was found, as the evidence was accepted of Colonel Guadleka. It was matched with SPA 249-14, and the conclusions on the record by Guadleka have already been placed on record. And since I'm pressed for time, also further, accused 1 says he is the only person who fired an object resembling a firearm, no one else. The grounds were inspected the morning of the event and no cartridges were found, and the area was declared safe. Therefore, the two cardinal rules for the court to draw inferences on the evidence presented, and which I have now stated on record as a reasoning as to the reasons why the court has arrived at its decision. I remind you the cardinal rules being, firstly, that the inference sought to be drawn must be consistent with all the proved facts, and secondly, the proved facts should be such that they exclude every reasonable inference from them save the one sought. In this instance, the question or the pertinent question then remains whether the court can infer, based on the reasons placed on record, including the evidence that it had dealt with over the last 2 days, whether such inference can be made. And the court finds as follows: indeed, the inference sought is supported by all the facts contained as per the evidence presented in court, and therefore the following findings are made. You may stand up, accused 1 and 2. Accused 1, in respect of counts 1, 2, 3, 4, and 5, you are found guilty as charged. Accused 2, Mr. Snyman, in respect of counts 4 and 6, you are found not guilty and discharged. You may be seated. Okay. At this point, the court will then just... Is there something you wanted to place on record?
Yes, Your Worship. I just want to say accused number 1 is no previous conviction.
Same is noted.
Just that because of the shortage of time, my instructions are to apply for postponement and for the continued release of the accused on warning. He's been on warning since the outset and has always appeared at court.
The court has no intention of changing the status of your client, Advocate Ode, so I am completely in agreement with that, and further that it's not possible to deal with the rest of the proceedings today.
As Worship will speak to that. In that regard, Worship, it's our intention to obtain a pre-sentence report, and for that purpose we need to arrange a date with Your Worship.
Okay, so at this point, just so that you may have a word with your client regarding his schedule, of course, Advocate Matthews, you are now excused from record.
I'm going to catch my train.
Yes, it will take you about a decade or so.
Could I just say something to you?
Yes.
I just want to thank you because you have been very patient with it. And you have, on many occasions, allowed the case to continue without us being present. Thank you.
Thank you, Advocate Matthews. It's much appreciated. Mr. Snyman, it will be your choice whether you stand down and leave Mr. Malema or if you want to remain seated next to him. That will... Sorry? All right, I assumed as such. Just to take instructions regarding the time frame, suitable date, whatever I have on a specific day, obviously I will have to clear or deal with as I had to do yesterday and today. So may I leave you with that arrangements and then return? It's 20 to 11. We'll return by 10 to 11. Is that in order? In order. Court will adjourn.